Hello, in this video we'll discuss characterization issues related to intellectual property. Now this is a continuation of the characterization of gains and losses. Now before we go into the actual taxation of intellectual property on a sale or exchange and how to characterize it, I want to look at non-intellectual property items, some of the big ones out there, and how we characterize them. And it's important that you've watched the characterization videos, the previous characterization videos, before you watch this video. This should be one of the last videos you watch. So accounts receivable and inventory are always considered ordinary in nature. They're never going to be capital or section 1231. So when you're thinking about characterization, think about it in the sense of ordinary, capital, and 1231 gains and losses. Remember that capital can be broken into long-term and short-term. When it comes to accounts receivable and inventory always result in ordinary gains, ordinary losses, always. And that's because, let's assume that we have a sale or exchange in all of these. So we're talking about sale or exchange with respect to all of these items. We're going to look at from the sense of the seller in this discussion. So we have the sale or exchange requirement that is needed to get capital or 1231 treatment. Main hodgepodge. You can have involuntary conversion in 1231, but we're just going to focus on sale or exchange. So now the next question becomes, okay, do we have a capital asset or a section 1231 asset? Well, accounts receivable and inventory are, under the definition, never capital nor are they 1231, so they're always ordinary. Next is securities like stocks, bonds, investments, right? Well, if you're an investor, they're always considered capital in nature. Capital, again, going through the definition of capital asset, from an investor standpoint, it will be capital. What if you're a dealer or buyer? Well, if you're a dealer or buyer of securities, that seems more like inventory, and therefore it will be treated like inventory is, as ordinary. Now, what if you have tangible property? And we're going to focus on tangible property here because we'll talk about intellectual property soon, which is intangible property. Okay? Tangible property that is used in a trade or business. Well, there's different types. What if it's personal and depreciable? So personal property, which means not real property. So everything else other than real property is personal property. So if it's personal property and depreciable, we have to look whether it's short-term or long-term. If it's short-term, it's always going to be ordinary. But if it's long-term, which is held more than a year, then it's going to be 1231. It's going to be 1231. Now, if it's considered 1231, we have to worry about section 1245 recapture because we do have depreciation. So we do have to worry about section 1245 possibly. What if it's personal tangible property that's used in trade or business but it's not depreciable? Well, that's going to be considered capital. You might be thinking, well, what kind of personal property can a trade or business have that's not depreciable? Let's say you go into a dentist or a physician's office. What do you see on the walls? Maybe you see some famous artists, right? Famous artists. Well, a lot of art doesn't depreciate. It simply appreciates in value. That's an example of personal property that's used in trade or business because it's used in the dental or physician's practice on the walls, right, of the business, but it doesn't depreciate. It appreciates a lot of time. So that is not depreciable property, and therefore, when we look at our definition of capital asset, personal property must be depreciable to get out of the capital asset definition. So that's going to be considered capital. Well, what if it's real property? Any real property, whether it's depreciable or not, if it's short term, it's going to be ordinary. If it's long term, it's going to be section 1231. Now, we don't have section 1245 recapture on real property. It only applies to personal property. Very important to understand. What if we have tangible property that is held as an investment? So what if it's personal property? Again, non-real. So everything else other than real property is personal. If it's personal property, then it's capital. And we have to worry about section 1245 if it's depreciable. So this is capital, personal property, whether it's depreciable or non-depreciable. What if it's real property and it's tangible investment property? Then it's going to be capital as well. And we don't have section 1245 because section 1245 only applies to personal property. So if you own a rental home that you depreciate, it's going to be considered capital under tangible, as you hold an investment, tangible personal property that's held as an investment, it's considered capital. Now remember, if something is considered capital, then we're going to have to classify it as long-term or short-term. Now what about personal use property? Well, personal use property, if you remember the big three, we have trade or business, we have investment, and we have personal use. Personal use being like your personal residence, your personal car. What if you sell that? Well, if you sell it for a gain, it's going to be capital. If you sell it for a loss, it doesn't matter because you can never recognize a personal loss. It would be capital, but unfortunately you can't take. So this really only applies to gains, but the character is going to be capital. When it comes to personal use property, we don't have to worry about depreciation because depreciation can only be taken on trade or business or investment property, so we don't worry about section 1245. Now what if we have capital and it's long-term capital gain? If you recall from the previous videos, that's good for the taxpayer because that results in lower tax rates, preferential rates. Now when we go through the section 1H determination, right, section 1H, we have the normal tax rate on long-term capital gains, which is the best rate, that's the best. Then we have under-captured section 1250, which is on that real property we talked about above, where it's subject to depreciation on real property. It's still a good rate, but it's not as good as the normal long-term capital gain. And then we have collectibles, which is a higher rate than all of them. But it's still, all three of these have a better rate than the ordinary rates. Okay, so that's just a general discussion of items that aren't considered intellectual property or intangible property, the normal items that we see in a business or just in general. And you can go through this and you can check, okay, how am I classifying things based on watching the previous videos? And that's how you can make sure that you've done these. It's kind of like a step to check your work. I've kind of helped you and guided you through it. Again, you need to focus on first looking at, is it defined as a capital asset? If it's not, is it section 1231? If it's 1231 or capital, do we have to worry about section 1245? If it's depreciation on personal property. Now let's talk about intellectual property, which all intellectual property is intangible. Very important to understand. It's intangible personal property. So we're going to talk about some of the major types of intellectual property. This doesn't cover everything, but it covers almost all. And you're going to see that while with the non-IP stuff, it seems that it's pretty straightforward once you go through the previous videos. With intellectual property, it's a little trickier. And this is meant to be just a basic discussion. It's meant to just get your feet wet to understand, okay, when it comes to intellectual property, it can be very, very, very challenging. It's also important that we focus on intellectual property because as our society becomes more and more service-oriented, intellectual property keeps increasing as the percentage of assets of our economy. So if you look at the percentage of assets back in, let's say, 1960 and what makes up intellectual property, it might only be 30% of the economy. When you look at the time of this video, it's about 70 to 80% of our economy. And in the future, it could even go up to 90%. So we're talking about the value of our economy, business economy, investment sector, and intellectual property could at one point dominate when it comes to the value of assets out there. Now, before we look at the specific application of the tax law to various types of intellectual property, patents, trade secrets, copyrights, software, trademarks, contract rights, goodwill, and covenants not to compete, I just want to make one thing clear is that over the history of the tax law, there has been change. Now, this video really focuses on the tax law is currently, but there is one point I want to distinguish, and that's the Tax Cuts and Jobs Act of 2017. Because before the Tax Cuts and Jobs Act of 2017, there really was very favorable treatment for certain types of intellectual property, mainly patents and software. And really, it's important to understand that the law did change after the Tax Cuts and Jobs Act 2018 going forward. And the discussion we're about to go into is the general idea before the Tax Cuts and Jobs Act, which you're going to see it's pretty much the same except for patents and software. Trade secrets also you could argue as well. And I will come back at the end of the video and I will bring attention to the things that did change. So the idea here is going forward is you need to understand the rules that are in place, which I'm about to go through, and then I'm going to come back and I'm going to say, okay, 2018 on, this is what changes, and it's important to understand that because, again, understanding the history because it could change in the future going forward as well. So with that, let's go ahead and let's talk about the various types of intellectual property. So the first type of intellectual property I want to talk about are patents. Patents have the most favorable of all characterization rules for all intellectual property. Okay? And you really have to break it down based on the creator of a patent, if they sell it, or a later buyer. So when it comes to the creator, there's really three different ways that we can have classification with respect to the sale by the creator. We can have section 1221 if it's an investment. We saw that, so we treat it just similar to what we saw of tangible property that was an investment. We can have section 1231, which is when it's trade or business property held for more than a year. Or we can have a special provision known as section 1235, which applies to patents. And all of these provide for potential long-term capital gain treatment. So that's very, very, very good. Now, section 1235 of all these provisions, again, focuses specifically on patents. Now, again, 1235 is only applicable if it's a creator. The creator is selling the patent. And there has to be a transfer of property consisting of all substantial rights to a patent or undivided interest, which includes part of such rights, all of such rights, by any holder. And if that is met, again, we have a transfer of property that's considered a patent, all the rights are in that transfer, then whether it's held for a day or 10 years, it's treated as long-term capital in nature. That is an excellent provision. And again, this applies to the creator. So we know about 1221, right? If it's, let's say the patent's held for investment, then with respect to the patent, it's going to be 1220, it's going to be a capital asset, so it'll be capital gain or capital loss, short term or long term. If it's trade or business and it's not, if it's for a year or more, it'll be 1231, which that's good, right? That's very good. But if we don't get 1221 or 1231, 1235 allows this other rule that says, okay, even if you have 1221 short-term capital gain, you potentially could still get long-term capital gain under 1235. So 1235 really trumps if you don't have long-term capital gain treatment under 1221 or 1231. Very interesting little dynamic here. Now, if you buy a patent from somebody, then there's really only two possibilities. And that's 1221 and 1231. Those are really the only possibilities. 1221 and 1231. There is no 1235. I guess another possibility is if the buyer only holds the property for, it could also be ordinary as well. If the buyer holds property for, it's trade or business, the patent's trade or business, and the buyer holds it for less than a year, well, you don't get that year rule for 1231, so guess what? It's going to be ordinary. But a buyer would probably try to hold it just to get the 1231 treatment to get the long-term capital gain or ordinary loss or whatnot, because 1231, remember, is taxpayer nirvana. Now, one other thing I want to mention before we go on to trade secrets is a provision that's, and I'll put this down for the creator, it's the research and expenditures provision, section 174. This is a huge benefit if you are a creator of a patent. If you're a creator of a patent, you simply don't depreciate the cost of the patent. You don't have to capitalize and depreciate it. Even though the patent usually has a life for more than a year, under section 174, the creator of the patent can actually expense the costs as they are incurred and through the process, the research and experimentation that goes into the patent. And that gives a benefit earlier on than simply having to amortize it over a longer period than when you're actually incurring it and when you're actually doing the research, when you're actually doing the activity. Now that's important to understand because if you do depreciate or amortize, you remember that you're subject to section 1245. Well, guess what? Section 174, the research and experimental, is not subject to any type of recapture. So if you sell the patent, the creator sells the patent, and let's say it's a zero basis. Later on, and it's long-term capital gain, let's say under section 1235, 1221 or 1231 and there was no depreciation taken, but it was all cost recovered through Section 174 at the time the research took place, you don't have to recapture. So all of that gain will still be long-term capital gain, which is good for you, even though you got the benefit of ordinary deductions later on. If you're confused about all this, go back to the depreciation recapture video where I talk about the problem and the solution, the cure. Really, Congress has not laid out a recapture rule. There's no recapture for Section 174. And because of that, that's a huge benefit. That's a huge benefit. Now, before I move on to trade secrets, I want to mention that the creator potentially could have ordinary gain or loss because again, if it's 1231 but it doesn't meet the 1 year requirement, it doesn't meet 1235 or 1221, it could be ordinary. So let's just put that down there. But that's very rare. I've never seen that, and I've never heard about that in practice. Again, because parties like to hold on, they can they can make sure they hold on to it for at least a year, especially if you're a creator. Usually because a patent, the process takes a while. So that's very important to understand. Okay, trade secrets. So trade secrets also have Section 174, and when we're talking about trade secrets, we're talking about formulas and scientific items just like patents. Patents and trade secrets both deal with scientific. Now again, we have to break it up by the creator and the buyer. So it's really the same for a patent except there's no 1235. So it's really the same as the patent, but there's no 1235 provision. That's very important to understand because 1235 again provides a huge carve out, So this one is still a pretty generous provision when you see some of the other rules. However, it's important to know there is no Section 1235. So again, the creator could have 1221, 1231, or ordinary based on the same kind of distinction that we made before. When it comes to the buyer, 1221, 1231, and ordinary as well. So it's the same as the patent, but there's no Section 1235. That's a very important to understand. There's no Section 1235. So you can just bring that down. Again, Section 174 also applies to trade secrets, so that no recapture issue is also available with trade secrets. That's extremely good for a taxpayer. Okay, copyrights. Copyrights are probably one of the most restricted. They have the least favorable rules for taxpayers. The least favorable. Now, if you're the creator of the copyright, almost always it's going to be considered ordinary because if you recall from the capital asset description video, whenever you create a copyright, it's treated as not a capital asset. It brings it out of a capital asset. Okay, that's very important. And you can't get it when you create it. It can't be a 1231 asset because it's not depreciable to you when you create it. Okay, that's very important. So when you create a copyright, it's ordinary. Now there's a carve out for the songwriting industry. Actually, the country music, Nashville lobbyists, they got to Congress, and there's a carve out that deals with songs, but it doesn't apply to film. Very interesting. So that's copyrights. That's the creator. The buyer, though, very similar to what we saw with patents, can have 1221 because if you remember, 1221, that special rule only applies if you create it or you gift it or whatnot, or it's in the same hands as it was. So if you have a copyright and you buy it and then you later sell it, 1221, 1231 are ordinary, same thing as what we saw with a patent. And the idea there is, again, if you're an investor and you're holding a copyright, 1221, right? 1231 is if you use it in your trade or business and you've been amortizing it. And then ordinary, right? Ordinary. And again, I want to reiterate that if you've been depreciating, if you're the buyer and you've been depreciating or amortized property, Section 1245 applies. So on that patent, on that trade secret, on that copyright, if you've been amortizing it, you have to use Section 1245. If you have long-term capital gain or 1231, you have to recapture. You have to use the recapture rules under Section 1245. So that's very important to understand. Very, very important. Again, though, if you have Section 174, like patents and trade secrets, you don't have to recapture, which is a very favorable rule. Very, very important, okay? So you're starting to see that that intellectual property is tough because you really have to look at what side you're on versus with the non-intellectual property, we can classify it a little bit more. It's a lot cleaner, right? This one, it really does. And that's really the purpose of this video, just to show you that when it comes to intellectual property, it can be really tough. So software is a very interesting animal. Software, it really depends. It depends. So again, we're dealing with sales. Purchases is a whole other issue. We can have many videos on purchasing software and how to treat it. It really depends. The sale of software depends on how the software is secured. Is it through patent or copyright? Now, almost always it's through copyright. It's very rare to find software that is patentable. It's very difficult to do and very hard. But almost always it's copyright. So if it's patent, we apply the rules just like patents. If it's copyright, we apply the rules just like copyrights. So again, it depends. So if we have a patent, we apply similar rules similar to patent. But again, that's very rare. If it's copyright, we apply the copyright rules. Very important to understand. Similar to copyright. Now, I also want to mention that software can get Section 174 treatment. It's possible you can get Section 174, even if it's copyrightable. So again, whenever you see Section 174, you have to be thinking in your head, that is an excellent benefit for the taxpayer because it's possible to get long-term capital gain or 1231 treatment, but not have to recapture the ordinary benefits you got when you were doing Section 174 before. So that's huge. That's a huge item, just so you know. Okay? Very, very big. Now, again, you might have to recapture under Section 1245, even if you're the creator. This is one interesting one. Software, sometimes even if you're the creator, you have to capitalize it, and then you have to amortize that software over time. Now, trademarks, we saw that patents are the most favorable. Patents and trade secrets have very favorable rules. Copyrights have the least favorable because if you're a creator, you're going to get hit with ordinary. Trademarks are like in the middle. They're like in the middle. They have some favorable and some not favorable. So we'll just say it's the middle. If you're the creator, there's a special rule under Section 1253. And what Section 1253 says is that if you don't meet certain criteria, you're going to get hit with ordinary treatment, and you can't get 1221 or 1231 treatment. You're going to get hit with ordinary. So 1253 brings in special rules that say, okay, if you don't meet these things, it's going to be ordinary. Very important to understand. That's for Section 1253. 1253 requires, first, that even if there's a transfer of a trademark or trade name that otherwise qualifies as a sale or exchange under Section 1221 or 1231, right, of a capital asset. So even if it goes through 1221 or 1231, it still can get ordinary treatment if the transferor retains a significant interest in the transferred trade name or trademark. So I just said trademark, but we're also talking about trade names as well. So this rule applies to both the creator and a buyer later on. It simply just applies to the seller. So the creator or the buyer of a trademark later on, both are subject to Section 1253. So that's the first part of 1253. The second part of 1253, it indicates that even if a transfer qualifies as a sale or exchange, the portion of the payments received by the transfer that are contingent on productivity or use of the trademark will be treated as ordinary income. So it's possible that some of the gain can be treated as long-term capital or 1231, but some of it can be treated as ordinary if it's contingent based on future events. This is very interesting. This is very interesting provision. I'm not going to go further, but I just want to bring attention to that 1253 basically throws a hammer in the trademark realm because it looks like, okay, trademarks are going to be a similar rule to trade secrets, but because of 1253, it actually brings in some extra requirements to get the preferential treatment, the 1231 and the 1221 treatment. So that's very important. So contract rights are an interesting animal as well. They're difficult because contract rights can potentially be ordinary or 1231 depending on the situation. and that is for the creator. The idea here is that if you have some type of contract right that you're selling to somebody and you create it, you actually secured those contract rights. Well, what the Supreme Court has said in PG Lake, which is an important case, is that you really have to look at the actual income that comes from it. And it's potentially possible, and this is just a general rule, there's a lot of exceptions to this and a lot of special rules, but you look at the income that comes from what is actually being secured. And if ordinary income comes off of that type of contract, you actually record the contract as ordinary. If it's 1231 in nature, it's 1231. Okay, so if it's some type of sale contract, it's going to be an ordinary treatment. But it's not that simple. Again, it gets a lot more difficult. If you're the buyer of a contract, though, and you later sell it, then what we do is, again, it's the same treatment. It's ordinary or 1231 under the same requirements. So the creator and the buyer here are treated the same. Just like with the trademarks, they were treated the same, whether the creator or the buyer were the 1253 and the 1221 and 1231. Same thing applies here as well. Very important to understand. Okay? Finally, the last thing I want to talk about is goodwill and covenant not to compete. So, goodwill and covenant not to compete, when you're the creator, almost always, and this is what I've seen in practice, result in long-term, well, they result in capital. Sorry. They result in capital. Because if you look at goodwill, is goodwill depreciable or amortizable? No. It's not, right? It's not. We know that and based on our previous discussions, goodwill, if you create the goodwill, internally generated goodwill is not amortizable. So that's very important to understand. And if you go through the definition of a capital asset, remember that if it's personal property, which is what goodwill is, it has to be amortizable or depreciable. Same thing with covenant not to compete. So there's some other revenue rulings and stuff on this, but this is just a general rule to make you understand. But if you buy goodwill, if you buy someone's goodwill, like part of a company, or covenant not to compete, can you amortize it? Yes. So when you buy goodwill, now, guess what? Now it's subject to Section 1231, or again, ordinary if it's not for more or less than a year. And you have to recapture any amount of amortization that has been taken. Okay, so I hope you've enjoyed this video. Again, this was meant to be just a basic discussion of intellectual property, intangible assets, and you see that it can get very tricky. So it's very important to understand that when you're dealing with these types of assets, for example, patents, you're dealing with very favorable. This is just to get you some themes. Trade secrets, pretty favorable as well. Copyrights, bad for the taxpayer, right? Overall, very bad. Unless you're a buyer, then it just seems like the ordinary things. Software is a very difficult animal, as well as contract rights. Very difficult. You gotta dig deep into it. Trademarks are somewhere in the middle between patents and copyrights. You can get that normal treatment of 1221, 1231, but you have to abide by Section 1253, which throws basically a monkey wrench into it. And finally, goodwill, which when you're the creator, is capital almost always, and then as a buyer, 1231 or ordinary, and again, you have to recapture 1245. So I mentioned earlier I would talk about the history regarding the taxation of intellectual property and how things have changed in the past and looking forward to the future and whatnot, the current law. So as you've seen, patents have very favorable treatment with respect to the taxpayer. However, that changed as a result of the Tax Cuts and Jobs Act of 2017. So 2018 and on, once the Tax Cuts and Jobs Act took place, the rules all still stay the same for intellectual property, but there's really three things: patents, trade secrets, and software that change. So these three things, they changed as of 2018. That's very important to understand. So before 2018, this was the treatment, and then after 2018, there's a few things I want to mention. And really the favorable aspects have kind of been leveled. That's the idea. And that's why I talked about this in the general sense first, and now it's best to talk about, okay, well, in 2018 and after that, what actually applies. So with patents, yes, they still overall are pretty favorable because Section 174 with the research and experimental expenditures can still be taken. However, the research and experimental rules change for certain types of things, and now not everything is going to qualify for immediate expensing and deductibility. It might be amortized over 5 years, which is much better than 15 years. If if you're a buyer of a piece of intellectual property, you have to amortize it under 197 and whatnot. But it could be 5 years. So that applies to patents. That applies to software as well. It's certain types of intellectual property. It's not everything, but it's some. So it's specified types. You got to be careful. Trade secrets as well. Again, could be changing, or could this could have an implication of that. So you got basically, I'm trying to warn you. You have to pay attention to that. With 174, you might still be able to deduct that all immediately, but 2018 after, some of those aspects under patents, under trade secrets and software, some of those things, that's not always the case. It might be over 5 years for specified things, for specified types of research and experimental costs. So that's very important to understand, okay? Another thing with respect to patents and trade secrets is the 1221 for the creator. So really the things that change are the creator, because for everything with respect to 2018. There's only 3 things that changed 2018 after, from the Tax Cuts and Jobs Act of 2017, patents, trade secrets, and software, and it's really only to the creator where things changed. The creator. The buyer, it still stays the same, but the creator, things change. And again, we just talked about the 174 changes for patents, trade secrets, and software. The next thing I want to mention, the last thing, only really applies to patents and trade secrets, and that really deals with 1221. So 1221, 2018, Section 1221, it basically treats it just like copyrights. That's a big change. Okay, so 1221. Remember how 1221 defines a capital asset, and it says that everything is a capital asset except for these things? Well, under the old pre-2018 internally created copyrights and similar things were considered ordinary, always, because they were not a capital asset and you could not get 1231 treatment as the creator. Well, now, under 1221, now it includes language that says patents, inventions, secrets, which can be viewed as trade secrets, and similar things as well, formulas and whatnot, okay, methods, those kind of things. If it's self-created, that can not be a capital asset under Section 1221. Now, here's something interesting, okay? 1235 was not overtaken by 1218. I'm sorry, by 1218, by the Tax Cuts and Jobs Act of 2018 and on. 1235 is still there. So patents, there's this issue out there where 1221 says, no, you can't, if it's self-created, you can't get capital asset treatment, but you still have 1235. So you got to kind of put that together and see how that's going to work, okay? And make sure, to look at the law regarding that thing, because when you're watching the video, there might be some updates on that. But that's something very important to understand. Trade secrets can fall in that category, just so you know. All right, so with that, I just want to close by going into the changes with respect to 2018. And whenever you're watching this video, make sure you pay close attention. There might be some small changes, but those are the big changes. And again, the Tax Cuts and Jobs Act of 2017 didn't really make too much of a difference. Still all the same application. Again, just the 174 items, research and experimental, most or some things now are 5 years. You can't immediately expense them. And again, the creator for the patents and trade secrets, now it basically is leveled for software, but then we have 1235 limit. All right, so I hope you've enjoyed this video.